Are you Ralph D. McLean?
Yes.
All right, this is Judge Middleton. You're in the right place, and you're in the right time. I can hear you and see you. You're a tenant in a landlord-tenant proceeding. And in such a case, you have certain rights. You have a right to have the case heard here in St. Joe County where the property is located. To have a jury trial, if you wish to have a jury trial, you must tell me this first court appearance, certain other conditions, which case the parties could file what's known as a conditional order of dismissal. And if both parties are interested, I can refer this matter to mediation for an attempted settlement. To log in here. Are you in the house on Day Road right now?
No.
Have you vacated that house?
Yes.
All right, it is 9:30. When did you move out?
June 26th.
Including out of the barns and outbuildings? Where are you living now?
I'm staying at my son's house, Fort Wayne, Indiana.
All right, Miss Alderson is here on our next case. Marcellus names. There was no lease here. This was done on a handshake or something. Did you know the Lettlingers?
Yes.
Are you related?
No.
All right, well, I'm gonna have you wait here just a couple of minutes in writing and turn in your keys within 4 days of your moving. Did you give them the keys when you left?
No.
All right, well, theoretically, you're supposed to give it to them within writing within 4 days of your moving. That triggers the security deposit law, but there was no lease. Did you even have a security deposit?
No.
Minutes, we're gonna address another case. And if they don't show up, I'll release you and then I'll just be prepared to dismiss this case. Miss Alderson, would you join us, please? Couldn't, yes, I can. Are you Davida Alderson?
I am.
Now, the other occupants are Lucille Bloom and Joseph Alderson.
My husband is working. I can.
Good morning. Excuse me. Good morning, Judge.
It's good so far. You can see out the window. It's a beautiful day here in Michigan. Great day to be alive. Miss Alderson, let me tell you some things that you need to know as a defendant in a landlord-tenant proceeding. The bank has foreclosed on your house and they want you to move. Hire a lawyer. If you can't afford an attorney, you can ask. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first appearance or make the demand in writing within 5 days using the jury demand form and be prepared to pay the $50 jury demand fee. You may be able to reach an agreement with your landlord, in this case, it's the bank with the plaintiff, by going through mediation, certain date and time, and they would agree to dismiss it. That would be called a conditional order of dismissal. Good morning, Ms. Long. You're our next coming case at 950 from Village Manor. Ms. Long, you're a tenant in a landlord-tenant proceeding, and your landlord wants you to move. They filed a termination of tenancy action alleging lease violations, including another unauthorized tenant. They served a notice to quit on you back in April, and they're asking you to move and to leave your tenancy. In such a case, you have a right to hire a lawyer. Mr. McLean, I'm going to go ahead and release you. I'll allow the case to go no progress after 30 days. All right, I think he had some technical assistance from his son, but he was here right on time. Good morning, Ms. Albu. The case at hand is Fifth Third Bank versus Lucille Bloom is not present. She was served by substituted service. From what I gathered from the defendant, they were buying the property on a land contract from Lucille Bloom. Doesn't appear Ms. Bloom was making her payments to the bank, and this matter was subject to a foreclosure. This house is at 501 Wood Street in Three Rivers. And Miss Alderson, that's not 501 Wood Street. You've got a background there. As a kid, I spent many. Ms. Albu, this appears to be pretty straightforward. There was a foreclosure sale last November. Then you'd get an additional 10 days from that date to move out. You'd have 10 days from that day to vacate or be subject to being evicted. Do you believe you can get out of there by the end of the month?
I don't. When attorneys first contacted us, they told us they would give us 90 days, and then we turned in our lease or our purchase agreement.
They have, the buyer has 180 days to redeem it. 13th, December, January, February, March, April, May, June. 180 days was up in June, and they're asking to foreclose. Now, I don't know when you got notice, but this didn't sneak up and bite them in the ankle. They had, as a practical matter, no payments have probably been made on this house for several years. So the bank wants to foreclose, and they want to clean it up, repackage it, and resell it. They can agree to give you more time, but by the letter of the law, this is the process that's followed in foreclosure actions. And the cold hard truth is the sheriff could come on August 1st and put all your stuff out in the street, whether you're ready to move or not. And Ms. Albu, do you have any discretion in this matter?
Your Honor, I could opt to 30 days.
30 days, which would be to August 11, August 10. But anyway, the wolf is at the door and the clock is ticking to midnight. So I'm going to leave this on for next, the 21st, and we'll see where we go. They would give you additional 10 days after that, which would be August 10th. I don't know when you got notice of this, but it was posted on the house. There were some other things. I think you must have known as of November they were trying to foreclose on it. And as a practical matter, I hope you stop making your payments to Miss Bloom. You may have been making payments to her. She wasn't making payments to the bank. So right now you're making no payment, which is good to help you get your next house. But the bank's not going to wait around till October. So right now we're just going to leave this on for July 21st at 10:45. Meg, I don't know that there's anything. Anyway, Ms. Alderson, I gave you the information for legal aid. discretion when we convene again, July 21st at 10:45. All right, well, you have the benefit of not making any payment right now. I don't know how long you're going to live without making a payment. So I'll see you on July 21st at 10:45. All right, stick with us here. Our Village Manor case is next. Ms. Kuzano is here. Ms. Long is here. I've advised the defendant of her rights while we had some dead time here. Good morning, Mr. Peters.
Morning.
You got your Zoom going. Good for you.
Yes, I do.
Good morning, Your Honor.
We've been waiting for you to show up, and so we skipped ahead. So stick with me for a minute. We're going to
Yeah,
take
my
up another.
apologies, Judge. I had another matter with you and I had them both scheduled at the same time in my head. My apologies.
All right. Well, I've got multiple other. All
Understood,
right.
Judge.
Let me call up this case, Orbit Leasing versus Trevor Arnott, 102 GC. Mr. Jeremy Chisholm is here for the plaintiff. Mr. Chisholm, I haven't seen you in a while. Good morning, sir.
Good morning, Your Honor.
Mr. Adam Taub is here for the defendant.
Good morning, Your Honor.
This is a claim for at least district court standards, a substantial amount of money, 18, regarding an automobile transaction. Mr. Taub has filed a motion to compel arbitration in this case.
In the complaint, a substantial amount of money, nothing to sneeze at. Potential counterclaims because this involves a car and subprime leasing, et cetera, in arbitration.
Mr. Chisholm, what's your position regarding the motion?
I guess, Judge, to be honest with you, I wasn't aware of the motion for arbitration. I did not realize that it was up today. I had this on my calendar as a pretrial. My general position on arbitration is that it's a waste of money in all but
Here's a thought. I'm inclined to grant the motion when they have competent counsel. What I would propose is maybe we adjourn this about 60 days. Mr. Taub, is that acceptable to you?
Yeah, I have no problem. I was going to say we can make this a lot simpler, and if Mr. Chisholm represents that he didn't get a copy of the 60 days is great.
That sounds good to me, and I certainly don't want to in any way imply that Mr. Taub didn't send me the motion.
Let's take up Village Manor versus Jessica Long. Mr. Butchart, would you join us, please? All right, well, let's call this case. This is file 261258 LT versus Jessica Long. Ms. Long is present. Also, the manager, Ms. Kuzano, is here, and Meg Bauer from the Glade. This has been filed as a termination of tenancy. It was filed back in April. I've advised Ms. Long of her rights as a tenant. The allegations are several, but one of them is that she has a unoccupied. Mr. Butchart, is that still the plaintiff's position? They want the defendant to move. Ms. Long, what's your position? You need to unmute.
So, I am a single mother of 6 kids, and I've tried to find places, but nobody around here has income based. I don't have like decent jobs. I mean, I tried. I've talked to Lori. And
All right, Ms. Kuzano, who is the alleged unauthorized tenant?
I believe it's her.
And he's not on the lease?
No, he is not.
he doesn't live here. I'm not sure because I was paying $116 and then it went up and down. So I'm not sure at this point because they haven't let me pay rent for 3 months.
On March 25th, you received a written notice of lease violation because you have an unauthorized occupant in your unit who has threatened other individuals on the premises. Your unauthorized occupant called another person a name, threatened to kill another person, yelled that he wanted blood.
Once again, he's not an unauthorized occupant. He does not live here. But he watches my kids for me, especially when I work. It makes it easier for me and I don't have to pay a babysitter.
Well, don't say any more about it at this point, but there's a fine line between, we've had this argument for dozens of times, which puts you and your 6 kids in a precarious position. The law requires that I continue this matter at least 7 days. Your rent's $116. If they get what they ask for, you and your kids will be homeless.
So,
What's Vladimir's last name?
Hofield.
I haven't had contact with him in a long time. He had a very serious charge 10 years ago. Well, that puts you and your children at risk. His charge was actually attempted murder in 2015.
Judge,
Ms. Kuzano, Mr. Butchart will continue this to Tuesday.
Will that next date be considered a trial date for the court, or is that a continued pre-trial
Well, we
date?
have 10 minutes, so I'm not sure we'll be having a trial. We'll see
Understood.
where we are. If we need a trial, you know, all that stuff about how many days his car's in the parking lot and who sees him and the other.
That works, Judge.
But
Thank
we
you.
are encountering the proverbial rock in the hard place.
Yes, good morning, Your Honor.
Morning, sir.
Okay, well, good. I was just making sure. We have it
it was-
resolved. I'm just waiting for the consent judgment to get back
All right.
signed.
I saw it was adjourned by the plaintiff. All right, Mr. John Peters is here. The file number in this matter is 24216. Well, let's discuss this. This is a claim for $3,600 or $480.42, attempting to garnish Mr. Peters' funds. In fact, I think they did seize his funds at Century Bank and Trust, which left him penniless on a probation. And he's doing very well on that probation, by the way. So he filed an objection. Mr. Peters, what's the nature of your objection?
I honestly didn't know anything about it. I never received anything in the mail. Didn't know this was happening or coming.
Well, they don't tell you, hey, we're gonna garnish your bank account in 2 weeks. Everybody would take all the money out of the bank. Yeah, let's talk about that. This was a default.
Yes.
The summons and complaint was filed in December of 2000. It was a Home Depot credit card, and they were suing you for $3,480. So they filed it with the court. Oh boy. Proof of service is in here 15 times. They sent it to you by mail at 1. They sent it in August. They sent it in July. They sent it on the 17th of September. They sent it on the 19th of August, 23rd of July. Looking for something that actually is a service other than first class mail. I don't know if I've ever seen this. They sent it on the 28th of August, again to the same address. 22nd of August. Then they filed a proof of service that says they posted it at that address and they sent it by first class mail. And then they sent it again. So we had an alternate service. They couldn't find you 12 letters to 18001M86. And then a default judgment entered in May, entered by default in the amount of $3,705.
Your Honor, based on his objection, there was no box even checked. So it's kind of hard to prepare for an objection when you don't know what the basis of the objection is. Punishment. So I would ask the court just to deny the objection and let the bank release the funds to us. We have received no payments since the judgment's been entered.
This happens a lot. Now, right now, you don't have any source of income. They're gonna seize. So let's say you do some work for somebody and build a porch or a deck and they pay you $2,000. You put it in the bank, they're gonna seize it. If
No.
you got disability and you put it in the bank, they can't seize that.
$96.79.
They're entitled to take that, but I don't want to just leave this garnishment in place. So we need to set up some sort of a payment plan. Can you, now, Mr. Groen, Mr. Peters is working on several different things. It's a long story, but he lost his identification. He also owes money to the court and has expenses for being on the probation. He is waiting for a potential disability settlement.
I have a suggestion then, Your Honor. Based on those circumstances, I mean, it doesn't sound like he has, as you said, a dependable source of income right now. So a payment plan probably is not the most feasible.
All right, let's do a hold on bank garnishments for the rest of the year.
You can feel free to touch base with our office and work out some type of payment plan.
Mr. Peters was not in a very good place in his life at the time this was going down. He's in way better position today than he was at that point. He's doing a very good job for our court and his probation. So I find that the objections are not valid. Mr. Peters, they're going to get to keep his money and apply to this debt. Any future bank garnishments? The bad news is you're not getting any of this money back. You had a Home Depot credit card. The good news is they aren't going to be able to do any further garnishments for the rest of the year. He's holding hope that they'll get this disability case. He's been riding his bike to court for every court appearance from Three Rivers, which is about 9 miles. It's actually 10:33. We're about 3 minutes late. All right. This was a case we heard last on June 26th. Demand for non-payment of rent. There was a very substantial alleged arrearage, 10,000 plus. The defendant was applying for a recertification. Mr. Butchart, what's the status here today?
Well, Judge, Miss Boyd and I, actually, my phone was ringing as I was finishing my last case with you. It was Miss Boyd returning a phone call I had placed to her earlier this morning, and we did have an opportunity to speak just a few moments ago. So I can the proposed consent judgment is for possession only for Judge, including July rent, we're showing a balance of 11. We have court costs of $201.62 for a total of $12,100. And Judge, I guess I would also say, yeah, if there's disagreement about those amounts, because we were only seeking possession in this file and stay in the property, I could just do a conditional dismissal, just simply setting them up.
Well, that's so you're agreeing to vacate by August 7th. So they've agreed to give you an additional 17 days beyond that. And that may be the end of it. If they're going to ask for money damages, we'll have and he's prepared to present what's called a conditional order of dismissal. If you pay the rent, you get to stay there, but you don't mining for something that I can't seem to find.
I do.
And you agree to move by August 7th?
Yes.
Do you know where you're moving to?
I'm still figuring that out.
Mr. Butchart will present a conditional order of dismissal.
Yes.
Term on the. All right, thank you.
You're welcome.
Stay in contact with your manager, Lori, and let her know what your plans are. If you don't vacate by August 7th, they can ask for a writ of eviction and have the sheriff put you out. That's not good.
No.
I'm still not sure how that got so big. A very good solution, except to move and start over.
Thank you.
All right, Meg, our next case is not for 20 minutes. Bodacious cowboys such as your friend will never be welcome here.
Fortunately, he's in the throes of chemo. So
Yes, I left the live stream on and shut the record off. We had about a 20-minute break.
Sorry, Judge, I did step away. I apologize.
All
for
right,
that.
let's blame you. We had a 20-minute break. Roger wired and Raywired. The file number is 261836LT.
Thanks, Judge.
We've got an hour block. All right, more of the world's most boringest live stream. It is 11. The clock just bonged at the courthouse.
I was I can't see the shirt, but I was just gonna say my clients have done what I wish most of my clients would do, which is turn their phone off when they go into a courthouse.
Well, they've paid all their escrow. They've been at every court proceeding.
Thank you. My gratitude to Elaine and Laura as well.
All right, that leaves just me here staring at the wall. So I'll sit here and wait. Thank you all for watching this. Not as boring as it gets. Today's first line of rock and roll poetry and a shared moment of humanity. Just when I say, boy, we can't miss, you are golden, then you do this. You say this guy is so cool, snapping his fingers like a fool. One more expensive kiss off, who do you think I am? Give a view of the empty courtroom.
Your Honor, thanks for waiting.
You're fine. In the meantime, I put Meg in anything you guys do to get closer to resolution is probably time well spent. So me and 5,000 viewers are sitting here watching an empty courtroom, but we'll see how long it takes.
Is there really 5,000?
Maybe 2,000.
Wow, that's pretty good.
Yeah, they heard you were coming, and so they.
Yeah, all my fans, right?
You can go on the YouTube channel for this. It's under my name and see, but yeah, it's a strange phenomenon. Colorado, California, Kentucky,
Wow.
Denmark.
Denmark. We're even international then, huh?
Yes, I have people that log in from the Faroe Islands and from. I'm gonna go visit the people in New Zealand, I think, in Melbourne.
Right. Well, those folks are like up probably around midnight.
Well, I don't know. I lose track. I know the California people are here 3 hours ahead of time, and the Colorado people. We're turning to Centerville Mobile Home Park versus Roger and Raywired. They're here at the courthouse. They've been in a conference room discussing matters with Meg Bauer from Legal Aid. This was filed as a termination of tenancy for the expiration of a lease for this mobile home in the park. Lease is up. Defendants have been paying their escrow payments each month and they're current. and the court is holding that escrow funds, other payments or other costs that might not have been readily apparent. As I indicated, this is not a non-payment of rent case. It's a termination of tenancy case. Question?
Yes, thank you, Judge. I emailed Attorney Landman after the previous hearing, asking if he could have his clients provide. I never got anything back. I understand Dan's and Attorney Landman's, but I confirmed with my clients again today that they would not have gotten it. They did not get anything from the courthouse in their mail. I'm wondering, I know the staff always sends those out. I don't know if they were returned as undeliverable or not. That's what
I
I'm
don't see
wondering.
them. I don't see them in the file, but I'm glad they're here. I'm glad you provided additional notice, but they aren't the only tenants that have had trouble with the mail. Centerville has a limited delivery, and they also have post office boxes in the courthouse. At any rate, well, let's talk about this case, Mr. Captain. I don't think you can do what you're asking to do. You can't do a termination of tenancy for the expiration of a lease.
Well, Your Honor, I think that there's a misunderstanding as to MCL 600.5775, which is the just cause termination statute in Chapter 57A. And its applicability to folks that rent mobile homes at mobile home sites, as opposed to those that own mobile homes at those mobile home sites. And I think in a mobile home park or tenancy. But then again, that's why we're here, because Michigan courts have long held that it's a duty of the courts to construe the language of the statute. In construing a statute, so that legislative intent has to be gleaned from the statutory text. So I think that it's ambiguous, and statutes are generally held to be ambiguous when either one word in the statute has an unclear meaning. So when it's ambiguous, judicial construction is necessary. And in that vein, and to that end, court has to consider both the plain meaning. So turning to this case, we look at Chapter 757. Legislature's intent becomes clear that that Chapter 57A is solely with respect to owners of mobile homes and not those that just merely rent those homes. I think 600.5781. So it says, Section 5781, if a tenancy in a mobile home park is terminated for just cause, explain the rationale for the adoption of the act, and I'd like to put that on the record, and that is that mobile home park tenants long complained that Michigan law treats those who own their mobile home, tenants in apartment building, for example, who receive a 30-day eviction notice, have 30 days to pack their belongings. Mobile homeowners, owners, on the other hand, must either move their mobile home to another park or attempt to sell the home in the park they are being evicted from. Although administrative rules governing mobile home parks require that tenants be offered a minimum 1-year lease, the rules do not require leases to be renewed. Also, many tenants apparently do not exercise the right to a year's lease. So they were just giving those that own manufactured homes the mobile home in a manufactured home park, because those are the same as tenants within apartment buildings. You know, it affected those with lower incomes, the elderly, because they didn't have the funds or means to readily move their, allow them to leave and take over the mobile home. So I think that the intent of the act was clearly to protect the financial ownership interests of mobile homeowners. The defendant wants the court to hold that any tenancy of a mobile home requires just cause. It flies in the face of not only the legislative intent, but looking at the statute as a whole. And with that, we ask that this court to construe the act consistent with the intent and grant judgment in my client's favor.
That was very impressive. You've done a deep dive, very deep dive into
Judge,
you're very helpful.
I'm prepared to respond to each one of the points my colleague has raised.
I'm ruling in your favor.
Can I make a brief record? Because I suspect this might get appealed.
Yes, I'm expecting it will also.
Thank you.
I've never encountered this issue in 24 years. The court has always treated a lot and trailer as like an apartment. I see other courts have wrestled with this issue, and it really boils down to the definition of what is a tenant. This law was drafted in 1961. The world's a lot different than it was then. I suspect there were very few cases where people rented the trailer and the lot, mobile home, manufactured home. As you know, they're working on updating this legislation. There are all kinds of problems that district judges are wrestling with. The whole issue of non-payment of rent. There is no clear answer. And I don't believe there's a clear answer to this, although you make a compelling argument, I think, all right, Mr. Kaptein has done an eloquent job of stating his position, which requires.
Thank you, Judge. I'm going to address my colleagues' issues in reverse order. Referencing the 1988 Senate fiscal analysis makes clear that the Senate understands the words, entering the arena is not proper when the language is clear on its face of mobile home owners. They've demonstrated that they understand that distinction. My colleague references MCL 600.5781, says that a tenant may sell their home. Illogical, of course, right? And the statute doesn't use binding language. The statute says the tenant may sell the home on site. Not all tenants, etc. But he says, well, hold on a second. MCL 5783 says that a judgment shall set forth the right to sell. But he's got to keep reading, because it also says that the judgment is ownership of the home. So in this sentence, to contort the statute into saying that it was only written, Summary Proceedings Act provides for mobile homes and those tenancies, and I completely agree with him. But he needs to look at MCL 600. There, Summary Proceedings Act says a tenant of a mobile home park is not considered to be holding over unless tenancy or lease agreement is terminated for just cause pursuant to Chapter 57A. That the Summary Proceedings Act, the act providing this court with the authority to proceed, we don't need to look at the rest of the statute. I submit that the statute is clear on its face and no further analysis is required. Insert an interpretation that adds confusion and ambiguity. When or how does one draw a distinction between owner of a mobile home park and a tenant? But it is a tenancy nonetheless. And they are tenants in this mobile home park. Therefore, their tenancy cannot be terminated without just cause.
Yes.
Because there are certain things.
Well, let me speak to this. I'm much less impressed with Senate physical analysis than I am with a court opinion or the statute.
The interpretation of the statute is to insert those who are a mobile home renter, because it says the tenant may sell his or her mobile home. It doesn't say the 5714 of the Summary Proceeding Act. It says a tenant of a mobile home park. So just taking the word tenant to mean simply in both statute, if you harmonize that, it doesn't make sense at all. Because taking tenant to mean both means that both can sell the home. So now if you take a look at Chapter 57A, it encompasses the in-person conference, the payment of rent and other charges, the sale of the mobile home, the judgment of possession, It actually makes more sense than the opposite, that this was only intended for folks that own a mobile home.
The level of advocacy here is quite high, and I appreciate competent counsel and eloquent argument. As I indicated, I haven't dealt with this issue in 23 and a half years, but others have. But as the defendant argues, the whole Summary Proceedings Act, Section 57, in 600-5714, paragraph 3, as cited by defendant, a tenant of a mobile home park is not considered to be holding over under subsection. So the Summary Proceedings Act says you can't terminate a mobile home. All right. The motion to terminate tenancy case is dismissed.
What about the
Yes.
$7,000 they owe me?
Release all the escrow funds to the plaintiff, $30. Denying the motion to terminate the tenancy, dismissing the case without prejudice. So I have $2,200, which will be released to the plaintiff, is dismissed. All right. I've ruled that the language of the statute was clear on its face. Also, the legislature is doing a major overhaul of the mobile home law.
All right, thank you, Your Honor.
Mrs. Wired, you're free to go. All right, that was an interesting case that was well argued by the attorneys, but I think the meaning of the statute is clear on its face.